let's talk special needs and planning and providing for the future. Now, what we have is, my name is Chris Chaney. I'm with Fort Pitt Capital Group. I'm a senior financial advisor. We provide high-end, tailored financial solutions to clients across the country. And we're delighted to collaborate with attorney Jillian Zacks to bring this program to you. You will, just a few preliminary notes to kind of help you get prepared for today's webinar. If you are on a smart device, if you're on a smartphone, take a look at the lower right-hand corner of the app. You will notice that there is an area down there, as you can see by the arrow, where it locates handouts and an area for questions. Tap on those if you have a question. If you're on a computer, as we are, please pull out the tab on the top right. You'll be able to see it, and then once you pulled it out, you will be able to pose questions and see our handouts. Now, there's going to be quite a bit of material here. This is a very deep pool, and Jillian is a phenomenal and seasoned expert. She knows this area. It's a lot. So we're going to be providing some information and a number of items for you to reference. So before we begin, a little bit about us. You see, parents of and relatives of special needs individuals face very different planning issues. When you first learn that your child or your relative has special needs, you enter a new world, a world with its own unique path and new questions. It's a journey of discovery and inevitably self-discovery. Both Jillian and I have had that experience. Both of us are parents of children with special needs. We've experienced the unique challenges and the unexpected blessings that this offers. We're incredibly grateful for the wide array of services and support that's available in this area. Some places have abundant resources, but many are very limited. One resource of special note is Wesley Family Services. Their caring, highly trained staff of nearly 1,000 people are committed to providing high-quality behavioral health care services and support programs to children, adults, and families over the course of their entire lifespan, so they're empowered to reach their full potential. They serve individuals with intellectual and developmental delays and disabilities through programs and initiatives that empower them to maximize their independence. Through their support programs, vocational training, residential facilities, and long-term care, the caring and dedicated staff meet individuals where they are and work with them every step of the way. They have been an incredible blessing to me and my family, so much so that I served on their board. If this describes your situation, I urge you to reach out to them. We will include some information about them in the handouts available with this program. Whether the resources in your area are ample or not, there are some planning issues that are common everywhere. We're going to focus on those today. So by way of introduction, Jillian Zacks is an attorney with the law firm of McAndrews, Mehalick, Connolly, Hulse, and Ryan. They have offices in Pennsylvania, Delaware, Maryland, and Washington, D.C. In addition to being an expert on special needs, which she is, she also has special expertise in trust and estate planning, estate administration, elder care, guardianships, and orphans court matters. A lot of these share common issues. She's constantly seeking to improve the lives of the vulnerable, and in that effort has served on multiple boards. These include ARC of Greater Pittsburgh, the Jewish Family and Community Services of Pittsburgh, and Achieva. Achieva is another great resource for those who have special needs. As a result of her extensive work in the community, she was awarded the prestigious Temple Grandin Award by the Autism Connection of Pennsylvania, and she's a delight to work with. With that, I give to you the expert in this area, Jillian Zacks.
Thank you so much, Chris. It's a pleasure to be here. Thank you for those kind words. I really appreciate it. Anytime I have the opportunity to provide information to individuals, I'm happy to do it. So if you know anyone out there is listening and you need someone to provide more information, please feel free to reach out. In addition to the special needs planning side, our firm also has a very robust special education side. So if you have a student with any issues in school, that's another avenue that you can pursue. And Nancy Potter is my cohort here and my colleague here in the Pittsburgh office. So without further ado, I'm going to start to let you know what we're talking about today. Our discussion will go through several things. So essentially, we're going to go through a basic overview of estate planning. What does every client who walks through the door to get an estate plan, what are they provided with when they go out the door? What will they have? Then what are we trying to protect here? When you have a child with a disability, there are certain means tested or public benefits that you are trying to protect. And then what are the methods of protecting it? What are the types of trusts that we can create to protect those benefits and enhance the lives of individuals? And finally, a new tool, it's been around since about 2017, is the ABLE accounts here in Pennsylvania and throughout the country. So we were going to touch on those as well. I did want to note that throughout my presentation, I will be using both person first and identity first language, as that differs in our community on what the individual's preferences are. So I will be using both throughout this presentation. So when a client comes through the office for estate planning, essentially you are walking through to get 3 essential documents. The first 2 cover you while you're living. Those are your durable financial power of attorney and your durable healthcare power of attorney with a living will component. The durable financial power of attorney is where an individual, called the principal, names someone called an agent to handle their financial affairs. It can be everything from going to the bank for someone, handling real estate transactions. There's many options, including what we call hot powers to change beneficiary designations, to do unlimited gifting. This document can be executed by anyone over 18. And I recommend it for all clients. Lately, we've been updating these documents for a lot of clients because last year, Pennsylvania enacted the Pennsylvania Revised Uniform Fiduciary Access to Digital Assets Act, which now allows you to put a clause into your durable financial power of attorney that will allow your agent to access your digital assets, whether you do online banking, your Facebook account, anything that if you're not able to do that, they can jump in and do. That's your durable financial power of attorney. Some individuals opt to have it springing, meaning it goes into effect when you become incapacitated versus when it's going into effect upon signing in the office. So that's your durable financial power of attorney. We are really careful when we work with clients to make sure that the individuals you are naming as an agent are someone that you truly trust, because this is quite a significant power that you're giving to someone to handle your finances. So we do have that discussion and we talk through that. The next document is your durable healthcare power of attorney, where you're naming, again, an agent to walk through that door into the doctor's office to access your medical records, to get over, as I call it, jumping that HIPAA hurdle so they can be with you in the doctor's office. And also it has a living will component where you get to decide in advance your end life decisions. So those are the 2 documents that cover you during life. And then the final one, which would be your will. And in your will, that's where you're deciding where your assets go upon your passing. It's often called the probate assets, the assets that pass through your will. In that document, if you have children under 18, you would create a younger beneficiary trust. We're going to talk later about the importance of trusts in different types of assets, where Chris will jump in and help us out there. The younger beneficiary trust, often I have parents that will say that my children can receive assets in staggered amounts at age 25, 30, 35. With different maturity levels and different issues, parents can stagger those ages for distributions at any point. It's also, if you have minor children, you will be able to name a guardian for those minor children in that document. So those are 2 of the big parts of a will. Where do you want your assets to go? Protecting those assets for younger beneficiaries or anyone else that needs protection, and also appointing a guardian if you have minor children. We're going to touch on guardianship of adults, but just know that if you are a guardian of your adult child, you can also place your wishes for a successor guardian in your will. It will still need to be approved by the court, as is the minor guardian, but your preferences will be given so that there won't be any question at the time of passing. Some of the other things that we do in estate planning, we can often create revocable trusts. That's also called a grantor trust. Sometimes when people would like a little more privacy in their assets, we can create the revocable trust and retitle assets into the name of the trust. Now, we talked about assets that go through a will. Those are called probate, but there are a lot of assets that are not probate. And if you then retitle assets in the name of a revocable trust, it does not go through the probate process, meaning upon your death, you go and you're sworn in front of the Register of Wills, and you take it through the process and you file an inventory and the estate is settled. So there's two processes there. The other thing we'll talk about more in depth is in the estate planning process, we will create a special needs trust. And if you have a child with means tested benefits. So we'll talk a little bit more about that. In Pennsylvania, one of the things to know, which is important in disability planning, is that upon age 18, an individual becomes an adult at the age of majority. That's sort of where your benefits change. They can apply for SSI, supplemental security income on their own, and Medicaid. You know, prior to age 18, your child may be receiving, or your family member may be receiving Medicaid through what we call the loophole in Pennsylvania. And they're not looking at the parents' assets. They're only looking at the child's assets. When they become an adult, they're solely looking at those assets. And you then are determined to be eligible based on several factors, which we will review. The other options when someone turns 18, just as we talked about for anyone walking through the door to get an estate plan, is to do a power of attorney. So if the person has the capacity to understand and execute a power of attorney, that will be done. And that allows you to continue, if it's healthcare and financial, to continue to go to the doctor's office with your child, to access their medical records. It doesn't take away anyone's ability to make their decisions on their own. What it does is allow you to step in and assist when you need to. So for example, you know, my kids executed powers of attorney when they were 18. I take it to PNC Bank where they bank. You know, we put it on file. So, you know, if one is not at home with me and they needed me to fix something in the bank, I would be able to do that. So it's definitely a great tool. The other reason it's good to have is if your kids are off at college and, you know, say they go into the hospital and you have that document then that says, I'm able to go be with them and access information. Very important. Some of the other types of protections you put in place, I've been doing a lot of mental health care powers. That is a separate document in the state of Pennsylvania where an individual can decide in advance when they have capacity to make their mental health care decisions. You can make decisions with regard to who you want to be your agent to help you. You can state which facilities that if you require inpatient stay, you would prefer to be in or not. You can decide on experimental treatment, ECT. All of that is outlined in the separate mental health power of attorney here in Pennsylvania. So that's another document that you can have in addition to the regular durable power of attorney. And finally, another thing that parents may do, or other individuals that are important in the life of a disabled person, if the individual does not have the capacity to understand making their own healthcare decisions, to make financial decisions, you can file a petition with the Orphans Court in Pennsylvania to become the legal guardian of an individual who is disabled over 18. It is a full court proceeding where you file a petition, you get an expert medical opinion as to capacity. We're now allowed to use expert medical reports. You submit that to the court. The guardians will testify before a judge. The individual who is alleged incapacitated will appear in court unless it's dangerous for them to do so or harm to themselves. Then the judge will make a determination on capacity and the appointment of a guardian. Now, after that, you then report to the court every year. You file an inventory, and there's documentation that needs to be done every year for protections, because you want to work in the best interest of the individual that has been deemed incapacitated. So we're going to talk about disability and who is considered disabled and why are we doing this planning. So an individual is considered disabled if they're over 18 and they're unable to perform substantial gainful activity by reason of an impairment which can be expected to result in death or which will last longer than 12 months. There's also an economic test that, and that figure is off. I needed to update that, but you can't make more than, I believe it's $12.90 a month or $13.30. I will check, but an individual cannot access, make more than that per month. If you're under 18, you need to have a medically determinable physical or mental impairment that results in marked severe functional impairments. So as we talked about it before, you can be considered disabled under age 18 and receive SSI based on a family income. Over 18, it's based just on the individual, and you have to meet that standard. You can receive Medicaid under 18 based on your disability under that guidelines that I just stated, and over 18 when you meet the criteria on the prior slide. Now, public benefits, as we talked about, are resource dependent, meaning you can't have resources typically over $2,000. So the individual applying for means tested benefits can't have an UGMA account with more than $2,000. They can't be making more than that monthly maximum in income, and you can't leave them as a parent anything over that $2,000 or they will become disqualified for receiving those benefits. So the means tested benefits that we're going to be addressing today are supplemental security income, Medicaid waiver programs. Some of those that individuals through the Office of Developmental Programs could receive is consolidated waiver, person family directed waiver. Those are some of the ones we see a lot of in our community. And then other things like SNAP benefits, used to be called food stamps, Section 8 housing, all of those are means tested benefits. There's other benefits that a child will receive. So age 18, child applies, gets SSI, they then get Medicaid, they're graduating high school, they then get consolidated waiver and they're living off on their own, and then a parent has a triggering event. That will trigger another benefit called SSDI. So the child of the parent with a triggering event, which could be death, disability, or retirement, will then get a bump up in their benefit based on the family maximum for that individual that triggered the event. So they will also, once you receive SSDI, within 2 years, you would then get Medicare. So that individual with that enhanced benefit will get what we call the dual eligibility of Medicaid and Medicare. So when you're planning with someone like Chris and you're talking about retirement, it doesn't just affect you and what you're picking for your level. It may affect the benefit that your child will receive. So that may be an important part of your planning when you sit down to discuss it. Chris, do you discuss that with clients, when to take retirement and what they should do?
Yeah, absolutely. It's vital. It's vital for the surviving spouse, if there is one. It's vital for the children, as you pointed out. Absolutely.
So these are the benefits that an individual receives, which we call means tested. And so how do you get what we call the best of both worlds? How do you provide for your child so they have all the assets they need to provide for them and also receive the really needed medical assistance benefit, that medical aspect for their care, in addition to the SSI? So typically SSI runs somewhere between $700 and $800 unless you're getting the SSDI bump up. Now that may not be enough for your child to live on, and you may want to provide for more. So how do we do that? How do we get the best of both worlds? How do we provide for our child or our loved one or a family member and still allow them to access the means tested benefits? Because you can't have an individual get more than $2,000 or they don't receive those means tested benefits. And as you may know, in the state of Pennsylvania, there's only so many spots for these waiver funds. So what a waiver fund is typically when you are receiving medical assistance, you have an institutional requirement. You receive the care in an institutional setting. But to receive those benefits in the community, to have supported employment, someone to go to your job with you if you need it, to live in the community with supports, that is waiving that institutional requirement and having those benefits received in the community. That's what a waiver is. So in Pennsylvania, there's a long list of people waiting for those waiver benefits because there's only so many spots. So you as parents want to plan, or as loved ones to plan, to protect that benefit, because if more than $2,000 goes into the individual's name, they could be disqualified from receiving that means tested benefit. So how do we plan for this? Well, we're lucky as estate planners and practitioners, we can create what's called a special needs trust. So you can provide for the needs of an individual to supplement their lifestyle, but not supplant what the government benefits are providing, like food and shelter. So there's several different types of special needs trusts, and it allows the individual, the beneficiary, to receive the things they need in life to enhance their lifestyle, but still receive those means tested benefits. And we're going to talk about the 3 types of trusts. The first type of trust is third-party funded special needs trust. And that is a trust that's funded with money that has never been in the name of the individual with a disability. The second is a self-funded special needs trust, sometimes called a payback trust or a first-party trust. And that's money that is the individual with disability. It's been in their name. They may have gotten it via gift. They may have gotten it through a personal injury claim. It may have been left as part of an IRA that someone forgot to change a beneficiary designation. There's all different reasons why people have money in their name. It could be simply an UGMA account that the parents created before there was a diagnosis and they had no knowledge of it. And then the final trust is a pooled trust, and that is held with a nonprofit organization, and we'll discuss that a little bit more in detail as the third element of the trust. Now let's talk about what applies to all of these trusts. There's some legal terms. Well, who is the creator of the trust? It's called the settlor or the grantor. They're the ones that establish the trust. The trustee is the person who manages and invests the money that is held in the trust. I talk about a trust as a box, and the box is controlled by the trust document. The person that created the box and put it together is the grantor or the settlor, and the trustee is the one that puts their hand in the box and then is able to decide which assets the beneficiary will receive. So in our case, when we're creating special needs trusts, it's an individual with a disability receiving means tested benefits. That is the beneficiary. So let's talk a little bit more about third-party trusts. So these are created by case law in Pennsylvania, not by statute. The person, as we said, with the disability is the beneficiary. Again, this is crucial. It is funded with monies that are not owned by the person with disability. You can create it in your will so that it's not created until you pass, and it has to be created through that probate process. Or during life, inter vivos trusts are created. That is my preference. We create the third-party trust, but we don't fund it. So typically, I'll use myself as an example. I have 2 children that are on the autism spectrum. They each have a special needs trust, third-party funded, but I'm going to provide for them during life. So that trust is not funded until my passing. So it's stated in my will that I'm directing those assets to go to this trust that essentially remains dry until it's ready to be funded. I am the trustee, and then upon my passing, there are successor trustees. And we'll talk more about trustees and how you pick them in a little bit. The important thing to know, and why we keep stressing the difference between these types of trusts, is the third-party funded trust that never has money from the individual with a disability in it. It's money from a grandparent, an aunt, an uncle, someone else. that does not have to pay back the Department of Human Services. Now, you heard me mention these first-party self-settled trusts, often called payback trusts. So what happens is when the individual with a disability is receiving means-tested benefits, in particular Medicaid, it's like Medicaid keeps a tab, so they know how much they've been spending. And in some trusts, there is a payback provision. So let's talk about that when we come to the self-funded trust, but I want to touch on some more issues with regard to the special needs trust for third party. Again, just as we discussed, this trust is to supplement but not supplant what government benefits are. So it's not going to pay for food and shelter. That's what your SSI is supposed to cover. And it's used for the beneficiary's special needs. And the trustee in this trust must have absolute discretion to make payments. There can be no ability for that beneficiary to have any say in these types of trusts. It has to be totally, the trustee has complete discretion to decide. That's an important factor. And you can't make income payments directly to the beneficiary. You can never give cash. The trustee can never give cash to the beneficiary, because then that's considered income. And remember when we talked about qualifying for SSI, there's three things: the inability to work, substantial gainful activity, resource limits, and income limits. So you've got this great trust and you've got it protecting, but if you're giving cash to the beneficiary, you're increasing their income and then you're going to disqualify them. So you have to pay to the vendors, directly. So that is things that have to happen for this trust are different than you might find with a trust you just created for an individual without a disability, as we discussed, like those younger beneficiary trusts that we talked about under the will. This is different. So as we discussed, you can create these trusts under your will, which is testamentary, or during life. Now, there is an opportunity to create trusts that can be funded during life, and we add special language to allow for that. Now, one of the important things to talk about is, we know if you have an individual in your family that's receiving means-tested benefits, and you want to create a third-party funded special needs trust with your money or someone else in the family, what is the best way to fund this trust? What are you going to put in that box, that trust box? So as we talked about, you can do lifetime gifting. You can just leave it as a portion of whatever is going through your will. You can also designate assets that have a beneficiary by naming that trust. Now, it's really important to remember that there are assets that go through your will and there are assets that do not. We call that probate and non-probate. Assets that don't go through your will with beneficiary designations are things like life insurance, IRAs, 401ks. Now, funding a trust with life insurance is a really good option, but you have to make sure that you're funding it with the right type of insurance. So I'll use myself as an example. I know that I'm going to need to provide for my children while we're living. I'm also going to need to provide for myself when I retire. So I think that in my situation, a life insurance policy that's permanent is the one that I know will always be there, no matter what happens at whatever age I'm going to be, to fund that trust. Those are often called guaranteed universal or whole life policies. Now, the other type of policy is a term policy, and they end after a certain period of years. That may not be there to fund the trust, but it's definitely something that you can look at as part of your plan for other options. Chris, do you have any input on when you're talking to clients about life insurance?
Absolutely. Oftentimes, as you pointed out, term is the least expensive option, as is the insurance that's available to you through work. But that's where it becomes critical to make sure that you've got your beneficiary designations properly aligned so that they do fund a trust that you would establish. But as you pointed out, as soon as you leave work, the work-based insurance disappears. And if you age, as you get older, term insurance becomes increasingly more expensive and eventually prohibitive. So that's where we want to tend to look at more permanent forms of insurance. But there are a wide array of those, as you pointed out.
Just on the insurance side, one of the other things to think about, we used to talk about different types of insurance, having disability insurance or long-term care. When you're caring for an individual with a disability in your home and then you need care yourself, oftentimes people do look to long-term care insurance that will provide for care in the home so that the individual can stay in the home with you. So there are all types of products. I think, Chris, there's now life insurance with long-term care riders, that if you don't use the long-term care component, you can then use it as a death benefit on the insurance. So it's definitely something to talk with a professional like Chris who understands this type of disability planning. It's a little different because there's other things to think about, the longevity of a policy, why you need it. The beauty of the life insurance is it goes into your trust dollar for dollar. It's cash. You're going to put the beneficiary as the trustee of, the Jillian Zacks, third-party funded special needs trust. It'll go in and it's immediately funded upon your passing versus having it go through that probate process that could take a year or so until those assets fund things. So there are different ways, to plan for this, and working with a professional like Chris is important because they're going to understand the nuances of that. So some of the things we want to think about when we're funding trusts and when we're doing our estate planning is to coordinate the plan. So we talked about those assets that pass through the trust and those assets that do not. One of the big assets that a lot of us have savings in are 401ks, IRAs, annuities, those qualified funds that are deferring tax. Now, there's special kind of planning we talk about when you're working with IRAs. It used to be that I would counsel clients, if you've got 3 children and one is receiving means tested benefits, you might want to leave your IRAs to those children that aren't receiving means tested benefits because it gets more complicated when you leave it to a special needs trust. Well, then happened the Secure Act in 2019 and all those rules changed. So it used to be, you leave it to your spouse, your IRAs, your 401ks, they spread it out over their lifetime in what's called a minimum required distribution. And then when they passed, if you have a spouse or if you don't and it goes to the next, to your children or whoever, they then got to spread it out over their lifetime with those minimum required distributions. The law changed. Now individuals only have 10 years, not the spouse, but after the spouse. And if you're not married, those individuals that you're naming have 10 years. That's it. Unless you're a minor, then once you turn 18, it becomes 10 years. But the big difference now is if you are leaving to a disabled individual, you can spread it out over their lifetime. But it has to be to a specific type of trust. So what I've been doing a lot lately is updating clients' trusts because they have to be accumulation trusts. So they have to be only for the benefit of the individual with a disability. It used to be that under case law, you would add in several beneficiaries of that trust, not if you want it to qualify for the stretch on the IRA or the 401k. Also, you can't name a charitable beneficiary or another trust as a beneficiary, so remainder beneficiaries even. So you need to be really careful in the drafting. So we've been doing a lot of reviewing of these trusts to make sure if you have significant assets in these qualified funds that you're doing appropriate planning. Now, it may be that that is not the best option to leave it to the special needs trust because in addition to planning to preserve their means tested benefits, we also have to look at the tax implications of leaving assets to trusts. And this is a little more complex, and that's where someone like Chris comes in, but you have to distribute that income out or there's extra taxes, and trusts pay at a really high tax rate. So although you can spread these out over the life of the individual, depending on the size of that asset, you may want to make different choices. Chris, do you have anything to add about seeing a lot of clients with large 401ks and IRAs?
Absolutely. The Secure Act has certainly limited the distribution options. And as you pointed out, if you're an eligible beneficiary, such as somebody who is disabled, who has special needs, you obviously can take it out over your lifetime. But to your point, it becomes critically important when you're dealing with a non-grantor trust, when you're dealing with a different tax ID, that it be managed extremely tax efficiently. Because distributions are only made for qualified expenses, if you don't have enough qualified expenses, you can't pull out that income. Suddenly you've got a lot of retained income, and that has all sorts of bad consequences. So to your point, it's critically important to be super tax efficient with any non-grantor trust for the benefit of an individual like that.
So important to really coordinate with your financial professional and your attorney to look at what the implications are down the road. Some of the other things to think about are making sure that you're coordinating all of this so that you don't leave an IRA or an insurance from an old job that you happen to continue and it names all children equally, or it names the individual with a disability directly. You want to make sure that you're pointing it to the trust in an appropriate way. Now, there's other things like 529 plans, UGMA and UTMA accounts. When you're applying for benefits, you want to make sure that you're looking to see if any of those are still in the name of the individual with a disability. If it's your child, did the grandparent create an UTMA? You need to find that, because that would disqualify them. So in addition to your own beneficiary designations, you want to make sure you're looking for those. The other thing to consider is Pennsylvania inheritance tax and federal estate tax. Pennsylvania inheritance tax when passing to a spouse is 0, 4.5% when passing to a child, 12% to a sibling. So that's something to consider when you're talking about funding your trust. How much money will be there after those taxes are paid, and is there liquidity to pay those taxes? The other two types of trusts we talk about are the self-funded special needs trust and the pooled trust. So we talked about what happens if the individual has money in their name and it's going to disqualify them. They have a personal injury settlement or an UGMA account that has $100,000 in it. You know, you can still fix that. They can still be eligible for their means tested benefits. You can put it in what's called a D4A trust or a self-funded special needs trust, also called a payback trust. And the reason they're called payback trusts is, remember I was talking about that medical assistance and sort of keeping the tab of how much has occurred. What happens when this trust terminates, the Department of Human Services here in Pennsylvania or any state that an individual has received these Medicaid benefits in is paid back. So they have a statement of claim. I have several cases right now I'm handling for trust companies where we're settling after the beneficiary has passed away. First, before any distributions can be made to the individuals designated in the document as the remainder beneficiaries, the Department of Human Services is paid back first. So that's why we call it a payback trust. So there's requirements on a payback trust. You have to be under 65 to create it. It can only be for the individual with a disabled. So the beneficiary has to be disabled. It can be created by a parent, a grandparent, a guardian, the court if the individual is incapacitated, or the actual beneficiary themselves if they have capacity. We talked about the payback. Again, the trustee has complete discretion. These have to be irrevocable or non-changeable. And again, same rules, supplements but doesn't supplant. So in both of these types of trust, third-party funded trusts, self-funded trusts, you are picking a trustee. It can be a corporate trustee. That's a company that's bonded. You want to pick someone that's experienced with special needs trusts. They understand what expenditures they can make so it doesn't affect public benefits. They're not giving cash. They're not giving income quarterly. You know, they have good record keeping. They have good trust investment guidance. But it can also be an individual. Often, you know, banks won't take certain amounts in trust. It could be $1 million is their minimum, 500,000 is their minimum. You know, So you don't have the option. You can pick either a nonprofit corporate trustee that will go below those, or you can pick an individual. Often parents may pick a sibling, one of their brothers and sisters, to handle the trust for their child, or they may pick siblings of the disabled person. All options. Another option is to create a co-trustee, have an individual who understands the person with the disability, or in serving in conjunction with the corporate trustee. Now, I have seen things arise, and I often caution parents to really know the family dynamics. Oftentimes it may be better to name a corporate trustee so that you can continue to facilitate that sibling relationship, the love between the family members, so that they're not the one that's paying the bills, making sure that the assets are invested properly. Or there are times when it's a conflict. You never know how people change. They get married. They may then have a spouse that says, well, if you're not making distributions to your brother or your sister, then we'll have more for our kids in the end. You don't think that will happen, but you just don't know. So I often counsel clients to think about all of these options. Chris, when you're talking with your clients, how do you discuss the trust options?
Boy, that's so important. And you're exactly right. It's great to have somebody who has some personal knowledge or connection to the beneficiary of that trust, but at the same time, to your point, it really does put the family members in an awkward spot. So we have an extended conversation about the family dynamics, the comfort that they would have, because you're putting the trustee in a spot where they're basically their guardian, their gate. So they might be saying no a lot of times, either to the beneficiary or frankly to the remainder, if there is a remainder. So it's an extensive conversation, and you have to be very delicate about it. Oftentimes a corporate trustee is the nice solution around it. It allows them to sort of assume the role of the stick instead of the carrot, and preserves that family relationship. But it's a critical part of any inheritance. It's actually a part of every estate planning conversation. What is the dynamic of the family? How will these proceeds affect them? Because as you said, money affects people. It changes how they respond, behave, perceive, and can change the dynamic permanently. So, yes.
And we're really lucky. We've got a lot of good corporate trustees that handle this in Pennsylvania and throughout the country, that work with specifically to the needs of individuals with disabilities. So, there are a lot of options. There's nonprofit options, so you can have some take anywhere over $500. There's private corporate options that they start at $1 million or $2 million. One of the things to be careful of is a lot of trustees may have handled special needs trusts in the past when you did your documents long ago, but they don't now. So you definitely want to keep on top of who are the current trustees that are handling this. Is that their forte? Is that something? Because you'll see on the slide that is in front of you that there's a lot of responsibilities for that trustee. Chris, how does it work if your client wants to still have you invest the assets, but also have when they pass, but also have a corporate trustee?
Absolutely. We have a lot of excellent local trustees that we work with, because that's a very special fiduciary responsibility. Now, we function as a fiduciary on the investment side, but we're simply appointed as the agent for the trustee, and then we continue to work with the family and continue to work with the trustee to make sure everything is kept in good order. And frankly, again, as I said, maximizing the return potential while at the same time minimizing tax consequence. One thing I will just add to amplify what you said, a lot of times if folks are not extremely well versed in the constraints of special needs trust and what is a permissible expense, you can get a nasty surprise. Give you an example. Trust that might buy a ticket, which is permissible, an airline's ticket for the child, may actually have that turn into income if it's a reimbursable ticket. So to know that you can buy a non-reimbursable ticket, but you don't want to buy a reimbursable ticket, that's a high level of detail. So to your point, it's really important to stay current.
One of the other things to consider is oftentimes a family member would like for the individual to remain in the home, and what's the best way. Some trustees will allow a home to be owned by the trust and others won't. So one of the things you are allowed to have when you're receiving SSI, in addition to a car, is owning a home. So some trustees, although they don't custody the asset of the house, they do pay for the expenses related that would not affect the SSI. So, you know, that's another thing to ask when you're picking a corporate trustee. What kind of assets will they hold? Some may even hold oil and gas royalties. We see a lot of that in Western Pennsylvania. There are just different types of assets that may be held in a trust. And again, you want to work with your financial professional, your estate planner to see what are you going to fund that trust with and what is the appropriate fiduciary to handle that. And I'm just going to touch briefly on the last type of trust, which is the pool trust. And this is run by a nonprofit fiduciary. What is happening is you're putting your money into the trust. It's used for the benefit of the disabled individual throughout their life. And then when that individual passes, that money that's left stays to be used for assisting other individuals with disabilities. So I see this a lot, you know, with you're now allowed to receive adult child support if you have a disabled child who's over 18. Oftentimes I see the pooled trust used for child support payments. I see it used for, you know, quickly, I mean, you can establish these within 24 hours. For example, one of the larger nonprofits here, Achieve a Family Trust, they have a joinder agreement. You can call them and you can then have this trust created pretty, you know, you fill out your forms and you can then put the money and you're not losing your eligibility for benefits. So I see this used a lot with all different types of assets, but it's a really good resource, especially when you're charitably inclined, to know that you're doing good to provide back to the community for an individual. So, you know, it can be money that is in the name of the individual with a disability, and it doesn't pay back. It goes back to, it doesn't pay back to EHS, it goes back to help others in the community. So that's the big difference with this pooled trust. And the final thing we're going to talk about, because we're almost out of time, is the Achieving a Better Life Experience Act, or as we all know it as the ABLE Act. What this essentially is like a 529 for an individual with a disability. It's under Section 529A of the Internal Revenue Code. It was passed back in 2014. We got it in Pennsylvania in 2017. That's when you could start opening them in Pennsylvania. I'm going to go through these slides really quickly, but please know there's 2 attachments to this presentation. One is a very detailed slide presentation, and then this one that you have right now. So there's a lot of information out there. So I'm going to briefly go through these ABLE account. So if you want to create an ABLE account for an individual with disability, they can create it themselves. The individual can create it themselves, or another can work if they're their power of attorney or their guardian to create it for them. You have to currently have been diagnosed with a disability prior to age 26. There can only be one ABLE account. You can't have like 3 for the same individual, one beneficiary, one account. Most of the states have them, but if it's not in your state, you can move, open one in a state that is joining with another. But we're lucky because Pennsylvania has ABLE accounts. I'm going to jump ahead to those slides. So if you would like to open a Pennsylvania ABLE account in Pennsylvania, you go to that website that's listed there, paable.gov. You can put into the account up to $15,000 per year based on the gifting. So currently it's $15,000. In Pennsylvania, you would actually get an income tax deduction on your Pennsylvania return for that amount that you're putting into the 529A account. It can be used for disability-related expenses, and it grows tax-free and distributes for those disability-related expenses tax-free. If you use it for something that is not disability-related expense, as is defined under the Act, there is a penalty, so you have to be careful. Now, having an ABLE account allows an individual to put the money, you can put up to $15,000 in there. It does not affect SSI until you go over $100,000. So you can have up to $100,000 in an ABLE account, you can still receive SSI, still receive medical assistance, and have that savings vehicle. Now in Pennsylvania, there's like 5 investment options that you have on the slides. The more detailed slides, it goes through all of those options. And you don't lose your medical assistance until you go over, like there's roughly a $500,000 figure. So I tell clients that this is a great tool in the toolbox. Use the ABLE account for gifts, grandparent gifts, you know, first communion gifts. This is a great vehicle, bar and bat mitzvah, whatever there is, you can put it into the ABLE account up to $15,000 and it will grow tax-free and distribute tax-free as long as it's for those related expenses. So it's a great tool in the toolbox. So you can start one of these now and have an ABLE account, but also create your supplemental needs trust or your third-party funded special needs trust to provide for more assets that doesn't affect the SSI. So this is a great vehicle to have and use currently. One of the other things to know about the ABLE account is, one, in Pennsylvania, there's no payback. So you don't have to pay back the Department of Human Services. Other states, that is required. So there is a payback provision, but not in Pennsylvania. It is not subject to Pennsylvania inheritance tax. Remember when we talked about that 0 for spouse, 4.5? You know, it may be that the individual with the ABLE account is leaving to their siblings. That's 12% of the asset. So that's, in Pennsylvania, there's no inheritance tax. But one of the other new changes is that, you know, maybe your child received an autism diagnosis at age 10 and you had started a 529 plan for college. Well, you can roll it over to another child or another individual, but you can also roll over up to $15,000 a year from your 529 college fund into your 529A or ABLE account. And the beauty is, if your child eventually goes on to college, there's so many great programs out there. This can be used for education too. So education is one of those qualified expenses. You'll see on the other slides that all of those, a listing of those qualified expenses are there. But this is a really good thing to know because I know from personal experience, we have 529 plans for college, but college may be started, it may not be finished, there may be excess in there depending on the program. So it's a good way to move those assets into the 529A or ABLE accounts. That's all I have. Chris, do you have anything you'd like to add?
Yeah, I'd like to just kind of bring it together. Thank you, Jillian. Phenomenal information. And again, I suspect many of you are feeling overwhelmed. And as I said earlier on, if that's the case, it's entirely normal. Frankly, you just dove into the deep end of a very deep pool. So what do you do now? The first thing that you want to do is get a good idea of both your child's specific needs and your resources. And when Jillian talks, she wasn't just talking about your own personal resources, but the resources that are available to you, such as Medicaid, such as Social Security disability benefits, things like that. Once you have a good idea of what you have and what you need, you as a parent will need to begin to become an advocate for them. Actually, you always need to be an advocate for all of your children, but this tends to be especially the case for a child with special needs. Why? The community is full of wonderful, caring, helpful people who are dedicated and seek to help and serve, but none of them are going to care for your child like you do, or your relative like you do. So a few thoughts to keep in mind, because if this falls on your shoulders, if you're the primary caregiver here, it's not unusual to keep in mind a couple things. It's not unusual for you to spend extra time and attention on the child with special needs. But if you do have other children, you want to be very attentive to and sensitive to their needs as well. This would normally be the case with any child. It's just a little more acute given the demands and the challenges that you have to address. Sometimes juggling these responsibilities can put a strain on your limits. You need to be attentive to that on your personal resources. So make sure that you cultivate a support network that can help you on this journey. And because it is demanding to juggle all of these concerns, make sure to take time for self-care. Now, I know this can seem absolutely impossible at times. Even so, if you don't care for yourself, there just won't be enough of you to go around to meet everybody's needs. So it's important. You are the foundation. Take care of yourself. So returning to long-term care planning, just to kind of recover what we've addressed so we can bring it back to front of mind. Good long-term planning is critical. It's difficult for anybody to plan for their entire lifetime, but you've got even more challenges when you're dealing with the potential needs and limitations that a special needs child will deal with. So it's critical that we do some very intelligent planning. So I want you to sort of refresh the financial options that Jillian talked about. As she mentioned, you're able to establish an ABLE account that stands for Achieving a Better Life Experience. It was a great idea. It just took the old 529 education financing accounts that are tax favored and expanded them to cover the needs of the special needs individual. And they're wonderful, and they also protect the benefits. Now, she mentioned there are limits. You have to qualify. So if you do qualify to set one up, great. This is definitely an account that you want to explore. A great resource as you're exploring this also is called the ABLE National Resource Center, or ABLE NRC. Look it up online, a terrific resource, nice one-stop shop. Second, as you are exploring the idea of establishing a special needs trust, remember, there are three kinds, just to kind of summarize. You've got the first party, which is the individual's own assets. They can be held in their own special needs trust. It can be held in a pooled trust. Either way, ultimately, once their needs have been met, it either goes back to the state in the case of the first party trust, or it goes on to a pooled account to take care of others. It's a wonderful alternative. You have a third party trust. This is funded typically by other people. Obviously, it's actually always funded by other people, but typically at death, but not always. As Jillian pointed out, some people may like to make gifts during their lifetime. It can be a very smart way to deal with your estate planning issues. So it's a nice opportunity to set something up. Now, if, as I mentioned before, and as she mentioned before, if this is a non-grantor trust, it's funded on death, it is critically important, super important, that this be handled in a very tax-sensitive fashion. So you need to have really a competent, proven, seasoned investment manager who can handle that responsibility. Non-grantor trusts, as we mentioned, are subject to extremely onerous tax schedules. There are other benefits that can be affected, so it needs to be tax efficient. Taking a look, again, revisiting, where do I start? Going back, you've got to cover all of those areas that Jillian mentioned that have beneficiary designations. If they have one, you need to change it. It's not only critical to providing the funding for the trust, it's really critical to make sure that there are no assets that pass directly to that child. Because if they do, they will undermine everything that you've just tried to do. So look at all of your retirement accounts, 401k, 401a, 403b, 457, IRAs, anything with a beneficiary attached to it. You may want to take a look at your insurance, any annuities that you have, or any insurance products. Real estate, as Jillian mentioned, can make sense if the trustee is able to accept them. It can be a very smart thing to do. In short, anything with a beneficiary needs to be redirected. In fact, just so you know, when Jillian created my trust for my special needs child, I went through and changed and updated every beneficiary I've got. Any place there is a beneficiary. It's critically important, again, to funding the trust and protecting the benefits that the trust is designed to protect. As I mentioned before, once you've got the trust established, it's important that whoever manages the trust, we obviously specialize in this, but whoever manages the trust are a fiduciary. They must put the interests of the trust first, always. Secondly, you're going to need a trustee, as Jillian mentioned. Again, if you use an individual, you're going to want to name a primary and probably a contingent, just to make sure there's another person to step into their place if something happens to them. A corporate trustee is oftentimes the most reliable way to ensure that they're going to receive proper administration through the lifetime of the child. Beyond that, as I mentioned, inside the investment trust, you want to make sure that we have a strategy that really serves the beneficiary of the individual. That is the individual that you set up to benefit. So we've got to have enough current income to meet their need, but be very sensitive to tax efficiency and really generate enough long-term growth to be able to support future income, because inflation can and does erode that. So these are some of the primary options that you will want to consider as you proceed. Now, big question is, when do you start? And the answer is now. The sooner you start, the more effective your planning can be. Now, these things do change constantly as the tax law change. So you want to be in constant contact with someone who's really an expert like Jillian. That requires revisiting those from time to time. Tax laws do change on average about once every decade. So it's really important, especially when you have a special needs individual, to take care of them. Make sure that their planning stays current. As she pointed out at the beginning, recent changes require revisiting this. So fortunately, we are in the position of helping clients create a strategy that's right for them. We're passionate about that. We want to make sure that all of our clients can have strategies that help them to live their very best lives. And this is especially true for a family that is concerned about the individual with special needs. So you're going to have questions, and we are going to address a couple that we have right now. But I do want to let you know you can reach out to me at Fort Pitt Capital Group, number 800-471-5827. You can reach out to Jillian Zacks at 412-313-55110. Now, I do want to cover a quick question here. We've got a number of them. Jillian, for you, can a trustee be changed after the trust is established?
That is a great question. Yes. So in the document, typically I put language in that allows for successor trustees. So if X person or corporation cannot serve, then you pick the next in line and the next in line. But also within the document, you have to make sure you're careful. You have removal powers. How does the trustee be removed if they're not performing properly or fulfilling their fiduciary duty? How are they, if they resign, how are they replaced? All of that will be in the four corners of the document, and it will spell out what happens in those situations. And when it isn't spelled out, there is an avenue to go to the orphans court and to litigate and to have a new trustee chosen.
Super. One last question is, suppose you've got an individual who's older than 65 for whom a special needs trust might not be easy to set up. What do you do when they actually are a disabled individual and they need to have care and attention? Is there a strategy that can be used to address the needs of somebody who is older than 65?
Yes, and that's specific to elder planning. So sometimes the pool trust can be used. But it's a different type of asset protection planning that is more complex with different type of income only trusts. So post 65 age planning is a different type of planning than we address today in our under 65 planning.
Fortunately, you're an
I
expert.
Can always answer questions about that, at a later time. There's a lot of different competing issues to qualify for Medicaid over age 65 when you have assets. There's community spouse allotments and different things that come into play.
Super. Well, we're a little bit over, but I do want to at least convey to all of you how much we appreciate it. Now, we're constantly trying to bring expertise and insight to all of your financial concerns. We have a couple of webinars coming up next week. Wonderful webinars and seminars, in-person seminars on how we choose stocks. As you can see, Nice Girls Don't Brag, Do They? That's an in-person seminar. So special events, I do need to share with you these important disclosures. And then again, I just want to thank you so much. We deeply appreciate your time. It has been an absolute pleasure to be able to offer the recognized expertise of Jillian Zacks and Fort Pitt Capital Group. Thank you very much. We wish you well. Take care.
Thank you.